Mentioning from the daily list.
Please don't mention anything. Just call.
From daily list, this
Some
case,
urgency
item
was
3, WPS
What
9/7 of 2023.
Ladyship, it's just that on the last occasion, the state had been directed to file a specific counter affidavit, and it has
What urgency I'm talking about?
Ladyship, I have not been given any
Mention
work,
rejected.
no termination.
Item 4, my lord.
Item
Allot-
number
Item
4,
3, call.
Allot 3 weeks time to file rejoinder only.
mentioning rejected.
Mention not I'm saying, but today. Allot
Case has been called out. You be there when the case is called out. Yes. Who is in this matter? Yes. Accused.
On the last occasion, my lord.
I hope your junior must have briefed
Yes,
you.
my lord. Last occasion, my lord pointed out, para 13 on the counter affidavit.
You forget about what we pointed out. You argue your own case.
Yes. The father of the petitioner died on 9/12/2021. My lords, I have prepared a list of
You just give the dates. 21 then.
21, my lord. Plus, his name was struck down with effect by order dated 27/12/2021.
27/12/2021.
Yes.
Then
The first application is dated 20/12/2021. That is the application made by the mother. 20/12/21.
mother.
हाँ.
She was seeking compassionate appointment.
She was seeking, मतलब she was recommending my name. फॉर्मल जो ये फॉर्म फिलअप हुआ है वो 3/1/22 को हुआ है. और मेडिकल बोर्ड जो असेसमेंट हुआ है वो 28/7/2022 को हुआ है. Now I have annexed my Aadhaar card and driving license. I mean, that is dated.
What is the date?
Of Aadhaar card?
No, medical assessment.
28/7/2022.
Yes. What is the age as per medical assessment?
They say, my lord, 36 years, 4 months.
37 years.
On the date of application, my lords.
37 years on the date, and on date of application?
36 years, 4 months, 22 days.
36 years, 4 months,
22 days.
22 days. And on date of death?
On the date of death, my lords, they have not said anything on this issue. Otherwise, if we calculate...
37 years on the date of death of father also we have said, my lords. In paragraph 13 it is
No, no,
stated.
my lords, they have stated, my lords, but the rejection order does not speak in that manner.
All right.
They are contrary to each other. But the impugn order and the statement made is contrary.
It is above 35 years. That is the NCWA says.
Because this says on the date of application my age is 36 years, 4 months, 22 days, and whereas in counter affidavit they say 37 years on the date of death. And they have not annexed, my lords, the document, the LTC document also, which they are.
They need not annex. You never asked for.
The order was, despite the order of your lordship, my lords, dated 7/2/2024, my lords. My lords directed them to produce the entire.
You tell us how your father has disclosed your existence in 1988.
But when it was recorded, my lords, it is not known, my lords. I have disputed
No,
that.
you need not.
I have disputed that, my lords.
Disputed? Where have you disputed?
My lords, para 4, my lords, I have stated in the rejoinder that all the statements which have been made is disputed, save and except, which is admitted, my lords. But there is one judgment which says, my lords, the LTC should not be taken into consideration, my lords. My lords, I have provided that judgment of Lilwa Bhuiyan, my lords. If my lords may have para 21 of that judgment, my lords. मैं para 21 of that judgment, if my lords may kindly consider. running page 5.
Yes.
Yes. Therefore, reliance having been placed by the respondent CCL on the LTC
So where is
form A
running page 5?
5 मतलब ये बटन दिखा देते हैं
है
ये यहाँ 5
Yes.
Yes. Therefore, reliance having been placed 21 by the respondent CCL on the LTC form A cannot be said to be justified once since the age of 15 years mentioned therein cannot be said to be conclusive age in absence of any date mentioned in LTC form A as to on what date and year the writ petitioner was of the age of 15 years. Yes. Then, my lords, in this case also, my lords, it is not clear as to when it was recorded, my lords.
1988 is not sufficient.
मतलब ये डिक्लेरेशन नहीं दिया है ना मतलब ये डॉक्यूमेंट ले आते हैं कि ये चीज लाने के लिए कि when it was recorded and when there was a declaration made by the deceased employee to the age of the petition, my lord. But then, my lord, page 27 onward, मतलब para 27 onwards, my lord. If I have put my line. But they themselves
Just a
say-
moment.
Yes.
Where have you denied the statement made in paragraph 13 of the contract?
मतलब specific
You said that you have denied it.
Madam,
Where is it?
para 4, my lord, of the rejoinder I have said.
You have not given para-wise comment first.
No.
Wait. Para 4 you have said what?
मतलब para said, para 4 that it is stated.
This is no denial. It cannot be taken as a denial. Anyways, you continue.
My lord, para 27 of that judgment. my lord. Para 27 to 33.
This judgment has been subsequently distinguished.
This judgment, my lord, thereafter was relied upon by various judgments, my lord.
It has been distinguished also.
That judgment.
In subsequent LPA, it has been distinguished. I am forgetting. You are not aware?
Well, it's, this one judgment I have brought up record when it's on the last occasion I had over. This is Tirath Mato versus.
Yes, Tirath Mehta. Where is
एक
that
वक्त हम
judgment?
एक बार कॉपी देख लेते हैं हम पढ़ा हुआ है मेरा तीरथ में तो
Where is that judgment? You have annexed it?
ये
I had already given it on the last occasion.
Like,
नहीं कॉपी नहीं
yes, you complete your argument.
है
That's it.
No. Even accepting the contention of the respondent.
What all documents do you have to support your age?
My lords, there is. My lords, I have annexed, my lord.
You just come to each one of them one by one.
Yes, certainly. I have annexed my Aadhaar card,
Where is it?
page 27, my lords. But this has been issued, dated, my lords. My lord,
When it has been issued?
31/12/2022. मतलब फोटो के जस्ट बगल में लिखा हुआ 31/12/2012.
Okay. What else?
The driving license,
Where is it?
मतलब page 28, my lords.
28. When was it issued?
This is 13 March 2027.
27, this is the validity. Issue date is 2017.
Yes.
Then what else?
The birth certificate, my lords.
Issued when?
It is 25/3/2022.
After death?
Yes, my lord, but complying with the requirements of the Act, my lords. There was a complete inquiry which I have also annexed, my lords.
This is date of registration. What is the date of birth?
Well, birth is being given this side, my lord. Left hand
fair-
side,
fair enough.
179018.
That's right.
Then, my lords, in my rejoinder, my lords, I have annexed the inquiry report.
Inquiry report of?
Of how the birth certificate has been issued, my lords. Because section 13(3) of the Birth and Registration Act provides, my lords, if there is a delay of 1 year, my lords, a proper inquiry would be constituted, my lords. Then, my lords, I have
Just a
annexed-
moment. Page number?
Well, starting from page number 9, inquiry report.
And which inquiry are you referring to?
Lord, the registration of birth and death.
No, which inquiry? I'm just talking about the inquiry. What inquiry has been conducted?
Well, the BDO office has conducted the inquiry, my lord.
How will they conduct the inquiry in this manner? They must have asked somebody.
Yes.
Where is it?
मैं जन्म रिपोर्ट में लॉर्ड, ये है पेज 16 से लेके पेज 16 18 में है, फिर 19 में है, पेज 13 में भी है। अभिलेख उपस्थित ग्राम पंचायत संख्या में पिता 1 वर्ष से अधिक, जांच स्थल का पता, महाशय स्थानीय गवाह जनप्रतिनिधि एवं स्थल जांच उपरांत स्पष्ट है कि आवेदक विनोद कुमार का जन्म 1 जुलाई 1979 में छोटी ग्राम में हुआ। Then, my lords, there is one more document, my lords.
That's all?
No, take out document. Admission register, my lords. That is of the year 2003, my lords. R2 पेज रनिंग पेज 20 से स्टार्ट हो रहा है। माय नेम अपीयर्स एट पेज 26 में।
It's 26.
यस मैम, ये
Where is
लास्ट फिफ्थ मैम,
it? Below.
विनोद मैम,
So,
भोपाल में है तो माय लॉर्ड। देन द नेक्स्ट पेज माय लॉर्ड, इसी के इसमें फिर डेट ऑफ बर्थ में 179089।
where is the application of your mother?
पेज 10 में एनेक्शन बी, उसके बाद हम ये दिए हैं, उसमें हम आधार कार्ड सब लगाए हैं, इसमें नहीं दिया हुआ है।
Page, where is the application of your mother?
मतलब द काउंटर एफिडेविट पेज नंबर 10।
Only read this.
अत्यंत ही दुख के साथ कहना पड़ा है कि मेरे पति श्री गोपाल महतो, जो कि सीसीएल राजरप्पा परियोजना खुली खदान में डंपर चालक के पद पर कार्यरत थे, जिनका PIS नंबर 67 है, उनका दुर्भाग्य से 4/12/2021 को मृत्यु हो गई है, जिनके जगह पर मैं अपनी ओर से सीसीएल के प्रावधान 9.3.0 के तहत अपने पुत्र विनोद कुमार को नौकरी देने हेतु अधिकृत करती हूँ, जिसके लिए उन्हें नौकरी का प्रपत्र निर्गत करने हेतु मैं रजिस्टर जन्म एवं मृत्यु नगर निगम रांची झारखंड द्वारा निर्गत मृत्यु प्रमाण पत्र का प्रमाणित प्रति इस आवेदन पत्र के साथ संलग्न कर श्रीमान के समक्ष उपस्थित कर रही हूँ। अतः श्रीमान से प्रार्थना है कि इस पर उचित कार्रवाई करते हुए मेरे पुत्र विनोद कुमार को शीघ्र नौकरी का प्रपत्र निर्गत करने का
And where is your application?
My application is page 22 of the writ petition.
And where is your family certificate?
I have not annexed the family certificate.
How many siblings do you have?
Perhaps one sibling is there. Have two. There is one more sibling. But the service records are with them, my lords.
चलिए, हो गया?
इसमें 2-3 जजमेंट खाली हम वही हम खाली दिखा दे रहे हैं कि कौन कौन सा जजमेंट है, व्हाट इट सेड।
You just refer to the paragraph.
Yes, settlement I have referred that in paragraph.
आप हम खाली paragraph बता दीजिए.
What is the judgment that has been quoted? That was
Just a
now.
moment, please hold. This is Lilua Bhuiya. Para number
Para number 27 to 33,
27 to 30.
33, para 21 and 24 also.
21 and
24.
20.
Yes.
Which else?
Chandradev Singh, my lord. Para 10 to 14, which was upheld by the Supreme Court, saying it to be groundless.
10 to 14. Let us see.
Yes.
Yes.
Yes. The undisputed facts. Yes. The undisputed facts in the case are that the mother of the writ petitioner was declared medically unfit as per the communication as contained in such and such. Subsequently, the mother of the writ petitioner made an application dated 25/7 before the respondent number 4, praying therefore appointment of his writ petitioner on compassionate ground. In view of the condition as stipulated under clause 9.4.0 of NCWA, the said claim has been considered, but subsequently it was rejected. Considering the age of the writ petitioner to be more than 35 years, the age of writ petitioner was determined by the medical board, wherein his age has been assessed as 37.5 years as on 23/9/2015. The writ petitioner has disputed the said assessment of the age by medical board by producing the document of his date of birth, that is school leaving certificate, Aadhaar card and voter ID card, wherein the date of birth of the petitioner was below 35 years. The said
This is on the dispute regarding date of birth plus minus 2 years.
Yes, my lord, this is.
Well, the same
But this is
documents
my
have been issued prior to date of application.
नहीं एक क्लियर दिखा दें. मतलब they have filed a supplementary counter affidavit. But they say the age range is between 35 to 40 years. हाँ पेपर खत्म दिखा देता है इसमें रेफर
Means all these documents in the judgment that he just now referred were issued prior to the date of application.
supplementary counter affidavit is page 7 man. On the radiological examination of the bones, the age of the candidate or the above candidate or the age assessed to be between 35 to 40 years.
That's right.
Therefore, my lord, these judgments have dealt with when there is 35 to 40 year of range which has been found in medical examination. The lower range has to be taken into consideration. My lord. Then, my lords, the other judgments are also in this line.
So 2 judgments should be sufficient?
My lords, as my lord wishes.
No. If it is on the same line, why repeat citations? That doesn't make any, that doesn't
Certain-
cut any ice.
certain-
These 2
certain-
judgments should be sufficient.
certain-
Yes, what do you have to say?
Minutes, the service excerpts of the employee, deceased employee, are normally taken to be true. In a writ proceeding, minutes, we cannot go into the question of whether the date of birth was correct or not. All the documents that have been relied upon by the petitioner are after the date of his first application, which was 25 to 2022. In the first judgment that he has cited, Melons, in the service excerpts, Melons, there was a difference in the dates. That is why the
वो
medical.
judgment भी थी ना
हाँ, तीरथ
अब
मातो
ये
का
थी ना
judgment.
तीरथ में तीरथ yes
So, well, it's in both the judgments that he cited. In the first judgment, in paragraph 15, it is said that the respondent CCL has relied upon the LTC form A, PS3, PS4 forms. In the LTC form A, age of the writ petitioner has been shown to be 15 years, while in PS3 and PS forms, age of the petitioner has shown to be 18 years. That is why there was a dispute, and therefore the committee had to be constituted. In our case, it has always been shown to be as 33, as per the medical committee's report, it was shown to be 33 years, no, not 33, 37 years. And therefore, in all the, as on the date of application, he was 37 years, as per all the documents that were given by the employee. And
That's
even while availing LTC facilities at the entire time, and Melons also in the second the second judgment that he cited, in that the documents have been issued prior to the date of application. In this, the date birth certificate that he's got, all of the documents that he's relied upon are after the date of application.
you file new documents in the rejoinder for the first time. This is the practice of our High Court, isn't it? You don't give an opportunity to the respondents to consider your case. You file a vague petition, get a counter affidavit, and file your documents in the rejoinder, such that there is nobody to verify that. Right? लिखो।
एक मिनट
नहीं हम देख absolutely
तीरथ महतो को हम एक बार दिखा
हम
देते हैं
पढ़ लिए।
नहीं लास्ट पैराग्राफ क्या बोला गया है कि
पढ़
हाउ इट वाज डिस्टिंग्विश्ड
हाँ
हां पैरा 29 है of that judgment.
I've read it.
Well, there is a wide variation of more than 8 years, my lord.
That's right.
Yes, ma'am. In this case, my it is not there.
Okay.
That is only my submission.
WPS number 977 of 2023. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the father of the petitioner expired on 9/12/2021. His name was struck off from the service roll of the respondents on 27/12/2021. Initially, the mother of the petitioner filed an application on 20/12/2021 seeking compassionate appointment for the petitioner, and formal application by the petitioner was filed on 3/1/2022. However, the claim of the petitioner for compassionate appointment has been rejected on the ground that the petitioner was overage
More than 35 years.
and was and on 2012-2021, his age was 36 years, 4 months, 22 days, and consequently, even on the date of death of his father, he was more than 35 years of age. The Learned Council has referred to the Aadhaar card and submits that the Aadhaar card shows his date of birth as 31/12/2000. Sorry, date of birth as 1/7/1989, and the issue date is 31/12/2012. His driving license also shows the same date, which was issued on 27 September 2017, and a birth certificate dated 25/3/2022 has also been issued, which shows his date of birth as 1/7/1989. The Learned Council has submitted that the birth certificate was issued after due inquiry. He has also submitted that the inquiry in connection, he has also submitted that the corresponding document in connection with inquiry regarding his date of birth prior to issuance of birth certificate has been annexed along with the rejoinder. He has also submitted that even in the school, his date of birth has been recorded as 1/7/1989. The Learned Council submits that there are clinching documents on record to suggest that the date of birth of the petitioner was 1/7/1989, and therefore the impugned order passed by the authority rejecting his application for grant of compassionate appointment on the ground that he was overage cannot be sustained in the eyes of law. The Learned Council has relied upon the judgment passed by this court in the case of Lilua Bhunia versus CCL, reported in 2021 SCC Online JHAR 1301, by referring to paragraph 21, 24, and 27 to 33 of the state judgment. The Learned Council submits that it has been held that if there is a range of age, then that is 35 to 40 years. In such case, the age 35 is to be taken into consideration. The Learned Council has also referred to another judgment reported in LPA 372 of 2021, decided on 7/6/2022, within bracket CCL versus Chandradev Singh, paragraph 10 to 14, to submit that in the matter of age assessment, there can always be a possibility of plus minus 2 years. The Learned Council has submitted that as per the supplementary counter affidavit, the age of the petitioner was assessed between 35 years to 40 years as on 28/7/2022, and the age has been determined to be 37 years. And in view of the ratio of the aforesaid two judgments, the age of the petitioner on the date of death of his father and even on the date of filing his application was less than 35 years. The Learned Council, appearing on behalf of the respondents, has relied upon a judgment passed by this court reported in 2022, volume 2, JCR 15, bracket Tirath Mehto versus, Central Coalfields Limited versus Tirath Mehto, decided on being LPA number 275 of 2017, decided on 27/1/2022, and has submitted that the judgment passed in the case of Lilua Bhuiya Supra has been taken into consideration, and it has been held that the and the state judgment has been distinguished. The Learned Counsel has further referred to the counter affidavit, paragraph 13, and has submitted that there has been clear that the various recordings in the service records of the deceased employee has been mentioned in paragraph 13, and which shows that even on 1/12/1988, in the LTC form, the name of the petitioner has been shown. Is that correct?
Yes.
The Learned Counsel has further submitted that
As
The
4 years.
ha-
on the LTC.
and his age was shown as 4 years on 1/12/1988. The Learned Counsel also submits that all the materials, including the medical board examination and different entries with regard to the date of birth of the petitioner, including his Aadhaar, birth certificate, etc., has been taken into consideration. And the documents which were never produced at the time of age assessment cannot be relied upon by the petitioner for the first time in writ proceedings, that too by filing a rejoinder to the counter affidavit.
Aadhaar cannot be accepted. because
सब
it's
है, Aadhaar card, birth
self-validation.
certificate, everything has been taken into consideration. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that a specific statement has been made in paragraph number 13 of the counter affidavit with regard to the entries in the service records of the respondents of the deceased employee. Paragraph 13 of the counter affidavit is quoted as under. A rejoinder has been filed to the counter affidavit in which there is no specific denial with regards to the statements made in paragraph 13 of the counter affidavit. This court also finds that the petitioner was subjected to medical examination and his age was assessed between 35 to 40 years as on 28/7/2022, and the medical board, while considering the age assessment of the petitioner, has taken into account the age in different service records of the ex-employee, which was indicated to be 38 years 3 months. The other documents produced by the petitioner, that is his affidavit, his age, his birth certificate as on birth certificate and Aadhaar card, have also been taken into consideration, and the medical board has ultimately found, upon consideration of the documents, medical examination, radiological examination, and related corroborating evidence, the age has been assessed to be 37 years as on 28/7/2022.
Since as per provisions of NCWA maximum age limit for dependent for
It is not in dispute that the maximum cutoff date for grant of compassionate appointment as per NCWA is 35 years. In the judgment passed in the case of Lilua Punya, there is no doubt that it has been held in the case of Lilua Punya,
Lower range has to be taken.
sorry,
This lower range has to be taken.
that's right.
This is from the
In the case of Lilua Punya, the age
There was a discrepancy in the age.
there was discrepancy with regard to the age of the writ petitioner of the said case, and he was subjected to medical examination.
In the service records.
Yes, discrepancy in the age of the writ petitioner in the service records of the company, and he was subjected to medical examination, and considering the various materials, ultimately the age of the petitioner was, writ petitioner was taken to be, कौन सा पैराग्राफ था एग्जैक्टली
exactly.
पैरा
Last paragraph.
yes and ultimately following finding was recorded, para number 35. नहीं लास्ट पैराग्राफ तो ऑर्डर को सेटिस्फाई. Where is it that the para number 30,
30 minutes.
para 30.
30.
It was held as under. ठीक है. The state judgment was subject matter of consideration in the case of was also considered in Tirat Mehto in CCL versus Tirat Mehto, decided on 27/1/2022, and this court recorded its finding with regard to age assessment as under para 28. wherein it has been held that the dependent of deceased employee are provided opportunity for fresh assessment of their age, provided they were in possession of Aadhaar card, driving license, voter ID, etc., under which the age is recorded different from what was recorded in service records of the employee. And this procedure was applicable only in cases where the service record of the employee disclosed wide variation in the age of the dependents. This court also recorded that in the said case, there was no such irreconcilable variation in the age of the writ petitioner recorded in the service records of his father. In all the forms / documents filled up at the instance of his father, the age of the respondent was almost the same. यहाँ पे कितना वेरिएशन है?
In the service records, there's
There
no
is no
variation.
variation.
There's about 3 years variation
2
in
to
the
3 years
2 to 3 years?
वेरिएशन.
as per his self declaration.
मेरा जो डिक्लेरेशन है और इनका जो डॉक्यूमेंट है उसमें 2 साल 3 साल का है.
इनके सर्विस रिकॉर्ड्स में तो सेम है.
33 and
हाँ.
37.
ये दोनों का वेरिएशन हम बोल रहे हैं.
That's it.
4 years.
In the present case, as per the counter affidavit, the declaration regarding the age of the petitioner as declared by his father and in the various documents of the service records of his father is consistent, and it also reflects that the father had given a declaration in LTC form
While availing LTC facilities.
by mentioning his age as 4 years as on 1/12/1988. The statements made in paragraph 13 of the counter affidavit has not been denied by the petitioner in the rejoinder, and the mother of the petitioner, by filing the application for compassionate appointment as annexed along with the
PS3 फॉर्म लिखवा दीजिए, नहीं तो गलत हो
Counter
जाएगा.
affidavit.
LTC फॉर्म में डिक्लेरेशन होता नहीं.
just a minute, as filed along with the counter affidavit, has referred to PS3 form
Yes.
indicating that the name of the petitioner was indicated in the PS3 form,
LTC
and in the counter affidavit with respect to PS3 form also, it has been mentioned that PS in inverted comma PS3 form dash 3 years as on 17/2/1987. In view of the aforesaid facts and circumstances, even in the PS3 form, it was declared to be 3 years as on 17/2/1987. In view of the fact that the service records, there was no discrepancy with regard to the age of the petitioner in the service records of his father, and further this court finds that the Age Assessment Board has taken into consideration all the documents which were produced by the petitioner and also the medical examination and the service records of the father of the petitioner. This court does not find any error or material irregularity in the manner in which the age of the petitioner has been assessed. Once in view of the aforesaid findings, this court finds no illegality in the rejection of the candidature of the petitioner by the respondents. Accordingly, this petition is hereby dismissed. एक और जजमेंट में हम लोग कंसिडर किए थे, हम डाल देंगे उसमें. पंकज जी, आप करेक्शन कर रहे थे ना? हाँ, एक और जजमेंट.
एक ही चीज बोलेंगे.
नहीं, अब हो गया बस.
नहीं, इसमें कुछ नहीं बोलेंगे. होता क्या है ना कि क्लाइंट सब आते हैं ना तो बहुत सारे डॉक्यूमेंट्स लेकर नहीं आते हैं. हम लोग
नहीं, आपने वहाँ पे भी नहीं प्रोड्यूस किया ना. रिट पिटीशन में पहली बार प्रोड्यूस कर.
नहीं लाए हैं, हम सब लाए हैं.
नहीं, आपने वहाँ पर भी नहीं.
बर्थ सर्टिफिकेट सब लाए हैं.
नहीं, बर्थ सर्टिफिकेट प्रोड्यूस किया है, बाकी स्कूल रजिस्टर और ये सब
वो
तो
सब
नहीं.
तो उतना दिमाग रहता है उधर.
चलिए.
From supplementary list to orders item 1, criminal division 40 of 2019.
He must have been released by now. Where is the petitioner? लिखिए criminal division number 40 of 2019. From the records of this case, it appears that by order dated 27/3/2019, the petitioner was directed to be released on bail by observing his custody period. However, one IA number 3344 of 2019 has been filed indicating that the custody period mentioned in the order was incorrect. And it has also been stated therein, on account of such fact, the petitioner was not being released from the jail. No, yes, are you there?
My lord, the arguing council has joined the judicial services, so I pray for and
It has been informed at bar that there are two arguing counsels. Both of them have joined.
my lord, SM Shahzad has joined.
So where is the other one, Mr. Faisal Khan?
He is not.
He has left practice.
No,
Then
he is practicing but not present today. Any adjournment may be given. He will be.
वकालतनामा साइन करना ना बहुत आसान है. Then you will say, I don't know. नहीं पता, नहीं जानते. Office is directed to call for a report from the learned court, from the concerned court, as to whether the petitioners have been released from custody, as it appears from the records of this case. That the petitioners were sentenced only for a period of 6 months. Let this order be communicated through fax. हाँ डेट इसमें चाहिए. एक तो डेट दे दीजिए, एक महीना बाद का. Post on 19th of April.
Item 2, criminal division 170 of 2019.
This decision has been directed under the judgment of acquittal passed by the appellate court by setting aside the judgment of conviction of the magistrate court, by the trial court. I have filed this application. There is a delay of 66 days in filing the present criminal division. I believe from the time I file IA, that may be condoned 67. Because there is this is not a case of concurrent finding, it's a reversal by the appellate court. And the informant the present
This is
appellate.
maintainable.
Yes,
Please satisfy.
my lord. Because
This is maintainable. This is against acquittal.
passed by the appellate court.
At whose instance?
To
The
instance of the
accused
respondent. The victim, who is the 498 case, the
and
informant.
the petitioner is the victim.
Yes. Victim as well as a complaint, informant.
A victim as well as informant.
Yes.
What is the remedy? You examine. There are so many judgments of this
There
court.
are two kinds of judgment has been passed by this one.
So please satisfy us on this. Please satisfy us on
Yeah.
this.
Because
You bring those judgments.
So that
ऐसे नहीं होगा. ऐसे verbally
there
नहीं.
is no objection on that point. Earlier, it is the case of 2019. And that is, there was no objection.
तो ऑफिस नहीं ऑब्जेक्शन करेगा तो हम
No.
आपसे पूछ नहीं सकते हैं.
Yeah,
तो ये कौन सा
They,
तरह का
I
argument है?
have not brought any
You bring
judgment.
it, you bring it.
Bring it because as per my knowledge, there are two judgments. One to Klal Yadav,
Please bring
that is
it.
the full court judgment.
अरे भाई आप जजमेंट लेके नहीं आए हैं, आप लेकर आए. Criminal Revision 170 of 2019.
Because it is a case of reversal, not a
We'll see that. आप जजमेंट लेके आइए, आपकी बात हम मानते हैं.
full court के
अरे
judgment के
भैया
हिसाब से
आप
revision
जजमेंट लेके आइए, नहीं समझ आ रही बात क्या?
4 weeks time.
आपकी तरह विद्वान हम नहीं हैं,
ठीक.
हम जजमेंट बिना देखे नहीं समझ सकते.
6 साल के बाद में ये ऑब्जेक्शन को 6 साल में 7 बार
अगर मेरा जुरिस्डिक्शन नहीं है ना, तो हम 6 साल क्या, हम नलिटी हो जाएगा ऑर्डर.
3 weeks time.
आपको रिलीफ कर देने के लिए हमारा जुरिस्डिक्शन देखने का मेरा काम है. ठीक है?
3 weeks time.
In the present case, by the impugned appellate order, the accused have been, the judgment of conviction has been set aside
By the appellate court.
by the appellate court, and the petitioner is the informant cum victim. Informant भी यही है?
एक बात हम बोल रहे हैं.
Informant यही है?
हम एक बात खाली बोल रहे हैं, जो हम टाइम दे रहे हैं, हमको जो जजमेंट है, जो एक जजमेंट के हिसाब से एक्विटल अपील होना चाहिए, क्रिमिनल रिवीजन यही होगा, फाइल ही हाई कोर्ट में होगा, लेकिन नॉमिनक्लेचर एक जजमेंट के अनुसार लेटेस्ट जो यहाँ से 144/2019 एक्विटल अपील के अनुसार इसको होना चाहिए एक्विटल अपील, और फुल बेंच के हिसाब से जो टुकलाल यादव का जजमेंट के हिसाब से इसको होना चाहिए रिवीजन. जो दोनों जजमेंट हम लाए,
ये आप लोग का काम नहीं है.
जिस समय ये जजमेंट आया ना, जिस समय हम फाइल किए उसमें ना टुकलाल यादव आया था और ना ही वो
एडवोकेट से ये सब कंफ्यूजन क्रिएट किया.
जी, नहीं सुप्रीम कोर्ट क्रिएट, ऑनरेबल सुप्रीम कोर्ट हैज
आप
क्रिएट.
इस तरह की भाषा का प्रयोग कोर्ट प्रोसीडिंग में ना किया करें. जब आपको लगे कि सुप्रीम कोर्ट से कोई कंफ्यूजन हो गया है, तो ये समझ लीजिए कि आपको सुप्रीम कोर्ट का जजमेंट समझ में नहीं आया.
बिकॉज़ रीजन
हम तो ऐसे ही समझते हैं, अगर
on the
हमको कोई
basis of the-
कंफ्यूजन होता है
on the
तो हम
basis-
समझते हैं कि हमको समझ में नहीं आया.
यस,
हम ऐसा नहीं सोचते हैं कि
ऑन द बेसिस
आप ऐसा कैसे बोल दिए. कंफ्यूजन हैज बीन
two
क्रिएटेड बाय
judgment has been
सुप्रीम.
passed by ऑनरेबल सुप्रीम कोर्ट ऑन सेम.
You might not have understood it. Read it properly.
यस,
Yes, you better.
3 weeks टाइम में.
I will give you 3 weeks time. होली वेकेशन में पढ़ाई करिए.
जी, फुल बेंच हमारा था, उसके बाद में सुप्रीम कोर्ट से. और यहाँ
आप हमको कहानी मत सुनाइए. ओके. The counsel for the petitioner and also the state.
Yes,
It is
ma'am.
your responsibility.
Yes, ma'am.
also. The counsel for the petitioner as well as the state are directed to assist this court with regard to the maintainability of the present revision application. For this, they jointly pray for time. Let this matter be posted on 18th of April 2024. एक मेरा भी जजमेंट है, जरा देख लीजिए. चलिए.
ठीक है, इसीलिए तो बोले एक्विटल अपील हो,
हम नहीं जानते.
लेकिन इसमें ऑब्जेक्शन नहीं था, इसलिए हम रेडी नहीं.
बहुत अच्छी बात है.
For press filing item 3, WPS 408 of 2023.
Yes, petitioner.
My lord, in this case, petitioner claim for appointment and for payment of yes, dues, my lord. Petitioner was appointed by Annexer 1 on 11/9/97 and worked till 2003. And subsequently, my lord, petitioner is under treatment, and when he become fit, they again approach the authority to accept his joining.
When?
My lord, that is Annexer 2. 2010 में.
फिर क्या हुआ?
So the authority not accepted the joining of the petitioner. Until date, my lord, department has not passed any order and initiated any departmental proceeding.
WPS number 408 of 2023.
My lord, at least my lord, dues
Counsel
may-
for the
dues-
parties are present.
dues
This writ
may be
petition
considered.
has been filed for the following relief.
इतना दिन काम किए उसका जो बकाया है कम से कम उसको कंसीडर
काम करने का एक भी डॉक्यूमेंट नहीं लगाए हैं।
ये दिए हैं जो कि एनेक्सर 1 ज्वाइनिंग लेटर
ये तो ज्वाइनिंग लेटर है ना।
हाँ
चलिए।
Leadership, just on the point whether he was present or absent.
No, no,
we'll have to see.
we will not reopen just dead cases, right? Heard the learned counsel for the parties, this writ petition has been filed for the following relief. The learned counsel submits that the petitioner was appointed as peon by the appointment letter dated 11/9/1997 as annexed in class, as per annexure 1 of this writ petition, and he worked till 2003. But no payment was made to the petitioner. He also submits that on account of medical reasons, the petitioner did not join during the period from 10/10/2003 to 10/12/2010 and got the fitness certificate on 10/12/2010, and when he went for joining by letter dated 16/12/2010, the petitioner was not allowed to join, and therefore the petitioner has filed the present writ application. Considering the amendments made in the writ petition, this court finds that the petitioner is claiming the payment right from 11/9/1997, that is date of issuance of his appointment letter, till 2003. And it appears that
जो
till
deducted amount-
2003, and it
deducted-
appears that
at least not a deducted
Just a
amount which was deposited.
just a moment, बीच पे मत बोला। This court finds that the petitioner has not even mentioned in this writ petition regarding his date of joining. No such document has been placed on record. It further appears that the petitioner claims to be under treatment from 10/10/2003 to 10/12/2003, but no medical document has been produced except one fitness certificate dated 10/12/2010. It is not the case of the petitioner that the petitioner ever intimated the employer regarding his illness or medical unfitness. The petitioner gave his joining with the medical certificate, claims to have given in his joining with the medical certificate on 16/12/2010, and the writ petition has been filed on 24/1/2023 without any explanation as to what the petitioner has been doing after 16/12/2010. This court is of the considered view that no relief can be granted to the petitioner on account of unexplained delay and lapses. Moreover, this court is not inclined to issue any direction upon the respondents to make. This court is also of the considered view that so far as the remuneration for the period 11/9/97 to 2003 is concerned, which the petitioner claims that he had worked, no relief to that effect also can be granted, as such relief also suffers from delay and lapses, and a portion of the period relates to prior to creation of state of Jharkhand. Accordingly, this writ petition is hereby dismissed.
Okay. Item 4 LPS 1244 of 2023.
See, yesterday this matter was taken up with the I have given an order passed in the case of one tender prisoner. Before that, I would like to invite your lordship's attention to the fact of the case that the petitioner has been appointed in the year 1985 and after rendering continuous service of more than 37 years, has retired on 31st January 2022. On the date of retirement, the petitioner was getting his fifth pay scale, salary in the fifth pay scale. Now the only issue before the loss is to be considered whether he is entitled for the revision of pension and revision of his scale in 6th and 7th and entire post-retirement leave benefit which have been withheld by the respondent state of Jharkhand without assigning any reason, but in the counter affidavit they have said that since the name of the petitioner was not appearing in SC Agarwal and SP Sinha Commission, so we have not given the approval for revision of pension. Now the sole issue which is required to be considered by your lordship that whether a person who has rendered his continuous service of 37 years on the strength of the order passed by the university in terms of the order passed by the Supreme Court in the case of Mahasangh, which I will be quoting bit after, and whether he is entitled for revision of his pension and salary in 6th or 7th month. In my humble submission, lordship, it is covered by a lordship's judgment and a coordinate bench judgment to be read with the judgment passed by the Supreme Court of India. Just to buttress my submission, lordship, I will be inviting your lordship's attention.
You see, just
Directly.
we'll ask them to consider your case.
Your lordship, but in my humble submission.
In the light of the judgments that you are citing,
What is the, lordship, with utmost humility I will be submitting what is happening, lordship, after disposal of this writ petition, the content petition is being heard by some other bench. If your lordship is quoting any judgment and the respondents in a most arbitrary and mechanical manner without any reasoning, they say that your case is not covered by, without assigning any reason, and the coordinate bench, while hearing the contempt, say that since they have rejected, you file a case, because I have been facing these situations in N
so at least there has to be one impugned order. There has to be one impugned order, because whatever you are saying, there are judicial pronouncements which are required to be considered. The judgment passed by the Honorable Supreme Court is required to be considered,
Yes.
and then it has also to be seen that even if your name does not appear in HC Agarwal Commission report, then also whether you are entitled or not entitled, because there is a specific notification issued by the university as contained in Annexure 3. And what is the consequence of that?
Annexure
Right.
4 is also.
Annexure 3 is also there, right? Your absence was to be treated as extraordinary leave, right?
Yes. That is
Yes.
not, may I submit, your lordship, subject list cancels. After this Annexure 4 was passed, which is more important, your lordship,
Yes.
I will be placing with your lordship's lead in supersessions of all previous notifications, your lordship,
Okay.
related to the candidates mentioned below and in compliance with the Honorable Supreme Court judgment in Civil Appeal number 6098.
In supersession, in pursuance of the
In
judgment.
supersession हो जो पेज 26
Annexure 4?
पेज 26 में पढ़े हो जो इन supersession लिखा हुआ
अच्छा वो दूसरा है.
है. Sorry.
ठीक.
In supersession of all previous notifications related to candidates mentioned below and in compliance with the Honorable Supreme Court judgment in Civil Appeal number 6098 of 1997 and in the light of the recommendation made by Honorable Justice Retired SC Agarwal Commission, the following non-teaching staffs of BNJ College CSI based on the recommendation of the committee constituted by University for the absorption of the services of non-teaching staff and on approval of the syndicate in its meeting held on 2nd March 2005.
This also refers to the Honorable Justice S.C. Agarwal
Yes,
Commission,
yes,
but
everything.
your name is not there.
Yes, Your Lordship, but what I intend to say, Your Lordship, has the occasion to see the judgment. Paragraph 49 and 50 of the judgment clearly speaks that it is, under 4114, it is the university.
That is why.
That is
why it requires a proper adjudication and proper application of mind by them. They will see those paragraphs
Your Lordship, I
also.
would be praying most humbly because 2 साल हो गया Your Lordship में direct I think
नहीं,
of course,
ऐसा नहीं.
but there has to be.
ऐसा नहीं होगा.
जो एक चीज और
नहीं
बोले,
नहीं ऐसा नहीं हो सकता है. We will ask very high
Because they have
official.
five-
Respondent number 2 shall do the needful.
secretary को कर दिया जाए तो डायरेक्टर भी बहुत सब
आप choose नहीं कर सकते. Director is the better person who will be able to do it, right?
and thereafter Your Lordship, even in the matters where name of, is not figuring, they have considered and they have taken decision in their favor. Again, annexure 4/1 is also one of such order by which my services has been regularized. It is so absorption is also there and regularization is also there. And under 4/1/14, since the university has exercised power, now the
What have they annexed? Annexure 4B is the annexure of
regularization you will see may see in pursuance of the judgment of the Honorable Supreme Court in civil appeal number so and so.
Nikki, heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner has been working in the petitioner was appointed as clerk in Bajnath Jalan College, Sisai, in the prescribed pay scale, wide, letter dated 1/10/1985, and joined the post on 4/10/1985, which is a non-teaching grade 3 post. His service book was opened and he retired the age of superannuation on 31/1/2022. The learned counsel submits that at the time of retirement, the petitioner was getting salary in the pay scale of 5th pay revision. However, the petitioner is entitled for 6th as well as 7th pay revision, and correspondingly the pension of the petitioner is required to be fixed. The pension with regard to the petitioner has not yet commenced. The learned counsel has by referring to the status of the service of the petitioner has submitted that the petitioner was working much prior to the cutoff date, that is 30/4/1986, and in view of the dispute with regard to regularization of employees working in one or the other college prior to the cutoff date, a 5-member committee consisting of vice chancellors of different universities was constituted, and a notification dated 6/10/1988 as contained in Annexure 3 was issued by the screening committee, and the name of the petitioner appears in the said notification. The contents of the notification is quoted as under. ये सब कोट कर दे रहे हैं जिससे उनको दिक्कत नहीं करने में, ठीक है? इसको कोट कर दीजिएगा यहाँ से यहाँ तक, पेज नंबर 23 में यहाँ से यहाँ तक. आपका सीरियल नंबर कितना है? क्या नाम है?
दिनेश राव, पेज 58, सीरियल 58.
सीरियल 58, सिर्फ सीरियल नंबर 58 को कोट करिएगा यहाँ से. Okay. The learned counsel further submits that the subject matter was the matter was again subject matter of challenge before the Honorable Supreme Court, and the Honorable Supreme Court appointed 1-member committee of retired Honorable Justice S.C. Agarwal to inquire into the matter and submit a report. And in the judgment passed by the Honorable Supreme Court, the report submitted by Honorable Justice S.C. Agarwal was accepted, and it was held that in view of Section 4(1)(14) of the Bihar State Universities Act 1976, the matter relating to absorption of one or the other employee of the newly converted constituent college was within the exclusive domain of the university concerned. And the Honorable Supreme Court observed that the state government had no role to play in the matter of absorption. The services of the petitioner was again absorbed, and a notification was issued by Ranchi University dated 9/6/2005 and 8/1/2007. The content of the said notification is as under. उसको भी कोट कर दे रहे हैं, ठीक है? ये जो ऊपर वाला पोर्शन है उसको कोट करेंगे। एनेक्शर 4 में है और एक पोर्शन है एनेक्शर 5। The Learned Council submits that pursuant to the revision of pay scale as per 5th Pay Revision Commission, the petitioner is entitled for fixation of his salary in the 5th Pay Revision with effect from 1/1/1996 and correspondingly and also and the university had revised and fixed the pay in the 5th revised pay scale with effect from March 2011. March 2011 से ना
हाँ
5th pay revision में तो आपको कोई ग्रीवेंस नहीं है।
दे आर नॉट अप्रूविंग इट, जिसके कारण वो जो उसका एरियर वेरी 11 से मिला, पीछे का एरियर नहीं मिलेगा उसको।
Okay.
अप्रूवल मिलेगा तो एरियर मिलेगा।
And the payment was being made in anticipation of approval of the pay fixation.
Yes.
The Learned Council submits that the petitioner would be entitled for 5th pay revision with effect from 1/1/1996 and no arrear has been paid for the period from 1/1/1996 to March 2011 to February 2011, and from March 2011 the amount has been paid subject to approval by the state government, but no such approval has been granted.
Yes.
The Learned Council submits that consequently the petitioner continued to work without final approval, and this fact was forwarded to the state government by the principal of the college by letter dated 19/6/2010 within bracket annexure 5, but no decision was taken. The Learned Council submits that in such circumstances the writ petition has been filed. He also submits that in the counter affidavit the respondent number, it has been simply stated that the name of the petitioner does not appear in the judgment, in the report, or in Honorable Mr. Justice Agarwal Commission report, Roman 4, capital B, and that the same was intimated to the university by departmental letter number 1009 dated 23/9/2011. The Learned Council submits that not only the report of the Agarwal Commission has to be considered, but also the judgment of the Honorable Supreme Court is required to be considered, and further the various orders which has been issued by the university is to be taken into account to decide the entitlement of the petitioner. The council submits that merely because the name of the petitioner did not appear in the commission report of Honorable Mr. Justice Agarwal, the same is not the same does not disentitle the petitioner for claiming the relief, as the case of the petitioner is covered by the judgment passed by the Honorable Supreme Court when read in totality. यही आपका केस टोटल।
Paragraph 49 was the judgment.
The Learned Council has referred to paragraph number 49 of the judgment passed by the Honorable Supreme Court reported in
2005 9 SCC page
2005 volume 9 SCC
page 129.
page 129. After hearing the Learned Council for the respondents has opposed the prayer of the petitioner and has submitted that in view of the counter affidavit, since the name of the petitioner was not appearing in the commission report, therefore the petitioner is not entitled to any relief. At this, the counsel for the petitioner has relied upon judgment passed by this court in WPS number 5151 of 2016 dated 18/9/2023, and also
In one of the judgments we have taken decision and given the benefit also.
Okay.
Recently, you see. And
and judgment passed in WPS number 481 of 2021 dated 7/3/2022,
With your lordship leave,
and the learned counsel submits that the benefit arising out of the said judgment to Yashoda Devi has also been conferred
yes, that
by
is
the respondents.
state.
Wide
Fixation का approval है वो सबसे.
White letter dated 17/2/2023 issued by the Director
Higher education.
Higher Education, respondent number 2.
May I be permitted to quote one? Well, see, I'm sorry, that was not available on the net. Read court order is not there, but contempt court order. WPS
इतना
number.
काफी नहीं है.
हुजूर इसमें
The
ये है कि
learned
अग्रवाल
counsel.
अग्रवाल में नाम नहीं इसलिए इसको दे रहे हैं. हुजूर का दूसरा ऑर्डर है जिसमें अग्रवाल में नाम है 4833 इनका रीड पिटीशन नंबर 4833 of 2018.
The learned counsel has also relied upon a judgment passed by this court in WPS number 4833 of 2008.
त्रिलोचन डॉक्टर त्रिलोचन महतो ने.
Yes, Dr. Trilojan Mehto and others, and has submitted that.
His name was also not figuring in Agarwal commission.
Yes, and has submitted that his name was also not appearing in the Agarwal Commission report, but the order passed by this court has ultimately been complied during the pendency of
Tendency नहीं जो appearance हुआ था फिर.
right, exactly. But has also been complied as is apparent from the order passed in contempt case within bracket civil number 370 of 2020. Right?
That will suffice.
The learned counsel has submitted that the respondents cannot treat different persons differently, and the petitioner is entitled to be treated at par with other similarly situated persons. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that different orders have been passed by this court in connection with entitlement of one or the other person, taking into consideration as to whether the name of such person is appearing in Honorable Mr. Justice S.C. Agarwal Commission report.
एक और था. In one of the cases, Your Lordship, one of the coordinated bench has said that you deposit it within 48.
Please, ऐसा इस तरह से मत करिए, okay?
Then,
I've heard you.
as you
I've recorded everything.
as you
बस अब शांत. डिक्टेशन के बीच में ना बोलने का कोई मतलब नहीं होता. आपका हर चीज आपका पोर्शन का डिक्टेशन के समय एवरीथिंग हैज बीन टेकन इनटू
As you
कंसिडरेशन. However, it appears that the matter regarding the petitioner with regard to his service during his service period also remained. नहीं ऐसे नहीं किया. However, the counter affidavit has only referred to the commission report of Honorable Mr. Justice H.C. Agarwal, and the records of this case indicate that the other orders and judgments passed by this court has not been taken into consideration while filing the counter affidavit. This court further finds that no adverse order has been brought on record by the parties with regard to entitlement of the petitioner, and it is only through the counter affidavit the respondents are opposing the prayer of the petitioner. In such circumstances, this court also finds that certain orders have also been passed by respondent number 2 as a follow-up orders passed by this court in the case of other persons. Accordingly, this court finds that the case of the petitioner is required to be considered by respondent number 2 in comparison with the case of other persons whom the petitioners claim that they are similarly situated as that of the petitioners. In order to accordingly, this petition is disposed of, enabling the petitioner to approach the respondent number 2 along with a copy of the writ records and a copy of this order. The petitioner shall also file the various judgments, orders, and directions issued by this court from time to time in connection with other persons, and along with the representation, and the respondent number 2 shall consider the case of the petitioner with regard to his entitlement and also with regard to his claim as comparison to other similarly situated persons. If one or the other similarly situated persons have been granted relief by the respondents, then there can be no reason as to why the petitioner will be denied of such relief. For this purpose, a reasoned order is required to be passed, and the respondent number 2 shall grant an opportunity of hearing to the petitioner. The reasoned order be passed within a period of 3 months from the date of communication of this order, after granting an opportunity of hearing to the petitioner, and the petitioner or his authorized representative. The reasoned order be communicated to the petitioner through speed post. If the petitioner is found entitled for one or the other benefit in connection with his service as well as post-retirement benefits, then respondent number 2 shall also take steps so that the monetary benefit out of the reasoned order is remitted to the petitioner within a period of 6 months from the date of the reasoned order.
So university has to make the decision. So may I have an observation?
We should take a decision
The-
on the approval.
Sorry,
The respondent number 2,
आपने तो भेज ही दिया था.
नहीं हम कह रहे हैं respondent number 2 has to take a decision on the proposal of the university. If a positive direction is issued by the directorate, Ranchi University will make the payment.
Okay, that's it. They will do it.
Yes.
They will just issue a direction.
Yes,
You had already recommended.
recommended the case.
आपकी तरफ से तो कोई
No, I am
pending नहीं
I
है.
am supporting.
ठीक.
May I-
The learned council for the university has submitted that the university had sent had taken steps for the purposes of approval, but the approval has not been granted by the state, and therefore it is for the state to take a call with regard to the entitlement of the petitioner, and university is ready and willing to forward any information that may be called upon by the respondent number 2.
Well, see, some time frame may be given to university also. University content is not-
Item 5, WPS 1319 of 2023.
Time till 24th April 24 is granted to the respondents to file a counter affidavit in the present case. Rejoinder, if any, by 10th of May, post on 14th May under the heading for admission. Next.
Item 6,
He has joined online. Counsel for the petition has joined online.
Yes.
हाँ भाई ये लिखिए through VC. Order में लिखिए. Next.
Item 6, WPS 1324 of 2023.
Same order. Counter by 24. Rejoinder by अभी कौन सा डेट बताइए. 24th and 10th. Rejoinder by 10th. It will come on 14th
Item 16.
under the heading for admission.
Item 7, WPS 1341 of 2023.
Same order. Next.
Item 8, WPS 1379 of
Same order.
2023.
Next.
Item 9, WPS 1404 of 2023.
Yes, petitioner. Yes.
Lordship, I was a Rojgar Sevak, Lordship. I joined in the year 2007. I worked till 2016, and due to illness, I gave a letter of resignation to my concerning authority, Lordship. In the year 2016, Lordship. It is an Annexure 5, Lordship. Till today, there is no intimation with regard to whether my resignation letter has been accepted or refused. And the subsequent development was that after about 6 months after my giving resignation, I got cured from my illness, and I gave a representation that I may be given an opportunity to serve the department.
When did you give
Yes,
that?
Annexure 6, Lordship.
What is the date?
Date is 17th February 2017, Lordship. 17/2/2017 को जो दिया,
और 2017 से 2023 तक क्या
फिर
करें?
2019 में भी दिया हुआ। लेकिन हमारा सिर्फ इतना ही करना है कि हमारा रेजिग्नेशन एक्सेप्ट भी होगा।
समझ लीजिए एक्सेप्ट हो गया, आपका पीरियड एक्सटेंड हुआ था।
पीरियड तो इन्होंने कभी नहीं एक्सटेंड किया। हम रोजगार सेवक थे 2007
एक ही साल के
लेकिन
लिए
मेरा
थे ना?
काम करते, हमसे काम तो लेते रहिए।
कोई आपका एक्सटेंशन तो नहीं है?
एक्सटेंशन तो
नहीं है ना?
नहीं, एक्सटेंशन नहीं है, लेकिन हमसे काम लेते रहे लगातार। ये कभी
2016 तक तो पेमेंट कर दिए ना आपको?
ये पेमेंट किए।
देखिए, WPS number 1404 of 2023. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner was appointed as Rojgar Sevak by letter dated 5/9/2007 as contained in Annexure 1 and is continued to work till 2016, and thereafter on account of some medical reason the petitioner could not, the petitioner tendered his resignation by Annexure 5 in the year 2016 itself, but there is no order of acceptance or refusal of such resignation letter. Thereafter, the petitioner, having recovered, gave his joining on 17/2/2007. 17/2/2007 within bracket Annexure 6. And another representation on 30/7/2019, but the petitioner was not permitted to join his duties, and consequently the present writ application has been filed. After hearing the learned आप oppose कर रहे हैं? The learned counsel for the respondents have opposed the prayer of the petitioner. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that as per Annexure 1, the petitioner was appointed as Rojgar Sevak under NREGA, NREGA, clearly mentioning that his appointment was for a period of 1 year. The petitioner gave his resignation. The petitioner has not brought on record any document showing renewal of his showing extension of his services. However, the petitioner claims to have continued till 2016 when he gave his resignation. And as per the writ petitioner, there is no specific order of acceptance or refusal. The fact remains that the petitioner again tried to join on 17 to 2017 by the Annexure 6 and has represented sometimes in 2019, but thereafter has filed the present writ petition seeking a relief that the petitioner be allowed to rejoin as Rojgar Sevak by ignoring his letter of resignation dated 26/5/2016. Considering the nature of employment which was granted to the petitioner only for a period of 1 year and there is no subsequent renewal of his contract of employment, this court and the petitioner, having resigned way back in 2016, has approached this court by filing the writ petition on 4/3/2023. This court is not inclined to grant the relief to the petitioner as prayed for in this writ petition, which is accordingly dismissed.
Item 10 WPS 1405 of 2023.
Annexure 3, page 20. That is under check.
We already should play for a short passover in this case.
Pass on.
Item 11 WPS 1428 of 2023.
This writ petition is maintainable.
Petition madam.
This writ petition is maintainable.
हाँ जो ये payment of the monetary compensation my lordship.
There is an award passed by the learned industrial tribunal. Go
Lordship.
and file your execution.
जो अवार्ड पास हुआ था जो उसने बोले थे कि आइडेंटिफिकेशन करने के लिए देयर इज डिस्प्यूट बिटवीन द टू वाइफ्स माय लॉर्डशिप, तो आइडेंटिफिकेशन ही नहीं कर रहे, मैनेजमेंट को ही लिबर्टी दिया गया
तो
था.
आप एग्जीक्यूशन फाइल करिए ना. You see, you cannot file a writ petition after an award passed by the learned labor court. ये executing court नहीं है. We will not permit this. There is an award in your favor, you go and file execution. ये थोड़ी है कि हाई कोर्ट में आप रहते हैं तो जहाँ आप रहते हैं वहीं पे SLP फाइल कर देते हैं, फिर तो आप सीधे सुप्रीम कोर्ट में 32.
जो यहाँ ऑर्डर आदेश हुआ था जो WPL में जो उसमें ये लास्ट में ये होता है this court finds no reason to interfere with according to the instructed application liberty.
You page number 22 of your writ petition. It is ordered to pay monetary compensation to the deceased workman's true wife after proper
identification में.
अब आप वहीं पे जाइए, execution या succession certificate लेकर हाजिर हो जाइए.
These are the two ways. Either
We will not entertain this writ petition.
तो सक्सेशन ये चूंकि
आपके लिए फ्री एडवाइस दे रहे हैं कि आप सक्सेशन ले ही लीजिए तभी अच्छा है, नहीं तो ये लड़ाई कभी खत्म नहीं होगी.
अच्छा ठीक
है ना. प्रॉपर एडवाइस कर दीजिए. इतना लड़ाई है वाइफ के बीच में, 2 3 4 शादी का कहानी है इसमें. हाँ, 3 वाइफ्स.
Admittedly, multiple marriages are there.
तो इसलिए 3 शादी किए हैं तो कुछ तो करना पड़ेगा. Counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the respondents has submitted that this writ petition is not maintainable in view of the fact that there is already an award passed by the industrial tribunal and this writ proceedings cannot be used for executing the award. The learned counsel submits that. Otherwise also the identity of the real wife is to be done and the petitioner has a remedy through the execution of the award passed by the She submits that the petitioner may also have to produce a succession certificate. After hearing the learned counsel for the parties and considering the fact that on an application that an industrial dispute was raised for the under section 10 of the Industrial Disputes Act, which was numbered as reference case number 10 of 2008. And ultimately, in that case, it was ordered to pay monetary compensation to the deceased workman's true wife after proper identification. In view of the award, this court is of the considered view that the present writ petition is not maintainable, as the petitioner has an appropriate remedy through execution proceedings as an appropriate remedy under the provisions of Industrial Disputes Act. The identity of one or the other wife, any proceeding with regard to identity of one or the other wife cannot be adjudicated in this case, and there is no private respondent in the present case. This writ petition is dismissed as not maintainable. Liberty to the petitioner to take steps as per law. नहीं, wrong advice से आप यहाँ पे petition file करें.
Item 12, WPS 144
Disposal करने, अच्छा ठीक है, disposal कर दीजिए.
बात ठीक हो जाता है, डिस्पोज ऑफ ऑब्लाइजमेंट
Disposal कर दीजिए. Respond number 1 and 2 file counter.
Respond number 1 has file counter. State has file counter.
1 and 2 has not file counter. 3 to 6 का counter. WPS number 1445 of 2023. Counter affidavit has been filed on behalf of respond number 3 to 6. The learned counsel for the respondents, respond number 1 and 2 is directed to seek instruction and file a counter affidavit in this case by 24th of April, rejoinder by 10th, post on 14th under the heading of admission. Next.
Item 13, WPS 1611 of 2023.
A department inquiry was initiated in the year 2010 for a misconduct 2007. However, my show cause was accepted, I was exonerated, and my suspension was revoked, and with all consequential benefit with continuity in service.
What is the
my grievance is कि
you consider his grievance?
Yes.
Who will consider?
Respondent number 4 representation filed before the respondent number 4.
No, representation नहीं, हमारा जो है सर्विस बुक जो है प्रेजेंट पोस्टिंग के जो हमारे अफसर उन्होंने फॉरवर्ड किया है टू द प्रीवियस पोस्टिंग, इसके वेरिफिकेशन करके भेजिए.
That's it.
वो नहीं.
लिखिए. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel submits that while the petitioner was posted as circle inspector at Ramna Circle, a show cause was issued to the petitioner on 9/10/2007, to which the petitioner duly replied.
I had not replied to that. During inquiry, I had submitted my.
Okay. Show cause was issued on 9/10/2007 and the petitioner was put under suspension on 11/12/2007. And ultimately, a departmental proceeding was initiated. The petitioner submitted his reply to the charges and the order of suspension was recalled on 7/1/2009. And during inquiry, no material was found against the petitioner and he was exonerated from the charges White memo dated 9/7/2010. The Learned Counsel submits that White order dated 1/7/2013, the petitioner was granted first ACP with effect from 13/5/2000. The petitioner was granted first ACP with effect from 13/5/2000. White memo dated 29/11/2007 and was granted second ACP with effect from 1/9/2008 by memo dated 1/7/2013. Thereafter, the petitioner was reinstated in service with continuity of service. Was reinstated क्यों होगा? Why
Reinstated नहीं है, suspension was removed, suspension was.
क्या लिखे हैं
Reinstated is Annexure 5.
Annexure 7. What is Annexure 7?
Annexure 7 is the representation.
The Learned Counsel submits that the petitioner was
Para 11.
the Learned Counsel submits that White Annexure 5 dated 9/5/2010 the petitioner was fully exonerated from the charges and the period of suspension was treated to be in service, right? The Learned Counsel further has also submitted that the respondent number 4 sent the service book of the petitioner to the circle officer Bansigar Nagar within bracket Nagar Utari bracket Bruce by letter number 93 dated 5/4/2021 and again to respondent number 3 by letter number 15 dated 28/1/2023 for necessary correction in his service book, but on account of the fact that the service book has not been corrected, the petitioner has not been granted the benefit of first ACP from 13/5/2000 and second ACP from 1/9/2008 and also the benefit of report of pay 6th and 7th pay commission report. The Learned Counsel submits that unless the service book of the petitioner is, unless necessary entries is made in the service book of the petitioner, the Learned Counsel submits that due to the fact that the entries are not being made in the service book of the petitioner is deprived of the service benefit. The Learned Counsel for the respondents has submitted that though no counter affidavit has been filed in the present case, but the grievance of the petitioner at the first instance can be looked into by the respondent number 2. Respondent number 2 कर देंगे Deputy Commissioner. After hearing the Learned Counsel for the parties and considering the aforesaid facts and circumstances and the grievance of the petitioner, this court is of the view that the matter is required to be looked into by the respondent number 2. Accordingly, the state petition is disposed of, enabling the petitioner to approach the respondent number 2 by filing a representation along with the writ records. The respondent number 2 shall ensure that if necessary entry is required to be made in the service book of the petitioner, the needful be done by the concerned authority, and if the petitioner is entitled for any of the benefits as claimed by the petitioner, that is, benefit regarding first and second ACP, and also with regard to sixth and seventh pay revision commission, appropriate reasoned order be passed after granting an opportunity of hearing to the petitioner or one of his authorized representative. The needful be done within a period of 3 months from the date of receipt of a copy of this order, along with the representation and the date records. The reasoned order be communicated to the petitioner through speed post. If the petitioner is entitled for any monetary benefit arising out of the reasoned order, the respondent shall take steps so that the monetary benefit is ultimately remitted to the petitioner within a period of 6 months from the reasoned order. This petition is accordingly disposed of.
Item 14, WPS 1613 of 2023.
Ladies, I'm just asking the passover and
WPS number 1613 of 2023, issue notice to all the respondents for which requisites under speed post as well as ordinary process be filed by Friday. By this Friday. Counter affidavit be filed by 24th April. Rejoinder by 10th, post on 14th under the heading for admission. Next. Notice कर देते हैं. There is a dispute. वो standing counsel है नहीं है, we do not.
Only this is without so far nothing. My appointment has been cancelled.
बिना counter के decide कर सकते हैं.
I'm just saying this fact.
Item 15, WPS 1626 of 2023.
Client को बता दीजिएगा आप appear हो गए.
Challenge is normalized.
Counter by 24th. He can see the proceedings also. Counter by 24th. Rejoinder by 10th. Post on 14th.
I have been exonerated departmentally also because and the criminal case was also.
आने दीजिए. Counter आने दीजिए. Counter देख के order. चलिए next.
Item 16, WPS 1962 of 2023.
Yes.
Lordship, counter is necessary, dismissal matter.
Dismissal matter है. नए सर्विस को दीजिए. या abandonment और सर्विस का matter. पढ़े हैं कुछ?
पढ़ लिया.
क्या पढ़े?
He has abandoned his service for 7 years, more than 7 years.
ये बताइए. Rule
Yeah, the
76
service
क्या?
code provides only 5 years is sufficient for dismissal.
बताइए. 5 साल से ज्यादा रहे ना बाहर. क्या बोलना?
इसमें हमको यही कहना whether the absence is willful or
5 साल अगर आप
due to compelling circumstances, इस पर कोई
आप ही बताइए ना क्या compelling circumstances.
हम 23/8/2010 से 15/11/2010 तक मेडिकल लीव में रहे. उसके बाद हम लगातार जो है लीव एक्सटेंशन के लिए, क्योंकि हम बहुत ज़्यादा बीमार थे, हमारे अपने वाइफ के थ्रू हम एप्लीकेशन दिलाते हैं.
कहाँ है एप्लीकेशन? कहाँ है एक भी एप्लीकेशन रिकॉर्ड पर? और कहाँ लिखे हैं कि आप एप्लीकेशन देते रहे?
हाँ लिखे.
कहाँ पर है बताइए?
So annexure 4 केवल देख लिया या पॉलिटिकल पार्टी के पैड पर इज रिक्वेस्टिंग.
तो क्या करेगा? आप लोग सुनते नहीं है तो पॉलिटिकल पार्टी के पास चले जाते हैं. वही ना इनके रिप्रेजेंटेटिव हैं.
अब उसी के कारण ये एब्सेंट है. He was involved in politics only.
Paragraph 8. That the petitioner remain under treatment of the doctor continuously.
क्या है इसका क्या मतलब? ना कोई डेट है ना कोई लेटर है. इस स्टेटमेंट को हम लोग क्या लिखेंगे? You take care of this statement para 8. ठीक है? You take care of para 8. देखिए, the matter relates to abandonment of service in terms of Rule 76 of Jharkhand Service Code. The learned counsel for the petitioner has submitted that the petitioner was under treatment for some time, and as per paragraph 8, the wife of the petitioner has been continuously reporting the health condition of the petitioner to the respondent. However, neither any supporting document nor any date to that effect has been mentioned in paragraph 8. Counsel for the respondents is directed to seek instruction and file a counter affidavit with specific reference to statement made in paragraph 8 of the writ petition, and also the provisions of law regarding applicability of Rule 76 of Jharkhand Service Code. The counter affidavit by 24th April, rejoinder by 10th, post on 14th under the heading for admission.
इसमें और एक है, इसमें रेट्रोस्पेक्टिव इफेक्ट सबको डिस्मिस किए हैं।
Item
The learned
17.
counsel has also submitted that petitioner that the order of dismissal has been passed with retrospective effect, and if the date of dismissal is taken to be the date of passing the order, the petitioner would be entitled for service benefits. यही ना कहानी है आपका? बस ठीक है। एक क्या नाम था इसका? डिवीजन बेंच में ऑनरेबल जस्टिस टाटिया डिसाइड किए थे, हम एडवोकेट थे, मेरे अगेंस्ट में डिसाइड किए थे, थोड़ा खोजिएगा जजमेंट कौन
एक चीज और
सा। बस हो गया, अभी आपका डिसाइड नहीं हो रहा है ना।
Item 17, WPS 1984 of 2023.
काउंटर का वही सेम टाइमलाइन 24, 10 and 14.
Item 18, WPS 2207 of 2023.
वन टू फोर का काउंटर चाहिए 1 to 4. देखिए WPS number 2207 of 2023. Counter affidavit has been filed by respondent number 5. Let the counter affidavit be filed by respondent number 1 to 4 by 24th of April, rejoinder by 10th, post on 14th under the heading for admission.
Similar matters are coming on
15th of
April. In WPS 2177 of 20.
इसको 15th of April को कर दीजिए. 14th April नहीं 15th April
15 May.
15th नहीं आप यही रहने दीजिए, let it be. एक केस डिसाइड कर लेंगे तो सभी आप ही है ना उसमें?
Yes.
बस ठीक, कोई दिक्कत।
Item 19, WPS 2212 of 2023.
Same order. Counter by 24th, rejoinder by 10th, post on 14th under the heading for admission. ये सारे matters admission में जाएंगे.
Item 20, WPS 2259 of 2023.
What is this IA? Caveat है. Somebody has entered caveat.
Pending आई नहीं.
I'm challenging the appointment
एक
of
caveat दिख रहा है इसमें.
April 9.
181. What is your timing?
So I have challenged the appointment of respondent number 8 and 9. It's a minority school institution fully aided by the government. The appointment has been made. It's completely giving a go by to Article 16 and 14. The president has appointed.
No advertisement.
Advertisement is there, but this is just a formality. The president has appointed his own close relative, and the secretary of the institution has also appointed his close relative. I have made such a statement. So notice will go to 8 and 9 as also the institution also.
This is all subject to confirmation by the Education Department, Director. That approval has been done.
A specific prayer I have made that the director should not approve till the matter is decided.
We will not decide it. It is for the director to decide. Director will see everything. Director will see everything at the threshold. You go before the director also you can go. If the proper procedure has not been followed, proper advertisement has not been done, because one representative of the state also should have been there in the board, we do not know.
But the writ petition is of April 2023, 1 year have elapsed. Maybe that he has approved.
We do not know. If he has approved it, you have to challenge it.
So it is for the respondents to say, otherwise how have we come to know?
You go there. If he has already approved, he will provide you a copy. If he has not approved, he will hear you also while granting it.
Because 1 year has elapsed.
I appreciate that.
Or my lord may keep it tomorrow or in the day after so that I can get instruction whether approval has been granted or not.
Nothing. WPS number 2259 of 2023. Counsel for the party petitioners and the respondent number 1, 2, 4 are present. Though a caveat has been filed in the present case on behalf of respondent institution, respondent number 5 and also respondent number 7, but nobody is appearing on their behalf. This writ petition has been filed for the following relief. Upon a query of this court, neither as the learned counsel for the petitioner has submitted that the matter relates to appointment in minority institution to which aid is being granted by the state. He submits that the entire appointment procedure is under challenge in as much as the advertisement dated 4/9/2022 was merely an eyewash and close relatives of the management of the school have been ultimately appointed. He has also submitted that the petitioners had participated in the proceedings pursuant to the advertisement. However, upon a query of this court, the learned counsel has submitted that the approval regarding appointment is to be granted by the respondent number 2, and as per the writ petition, the approval has not yet been granted. The learned counsel appearing on behalf of the state while opposing the prayer has submitted that since the approval has not yet been granted, therefore the writ petition is premature and the grievance which the petitioner has can be taken care of respondent number 2 by scrutinizing the records by granting the approval regarding appointment of the private respondents. At this, counsel for the petitioner submits that this writ petition was filed as back as on 27/4/2023 and much time has elapsed and he is not aware as to whether the approval with regard to the appointment involved in the present case has been ultimately granted by respondent number 2 or not. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the process of selection in minority aided institution was undertaken and the petitioners had participated in the selection process, but the petitioners have made allegations regarding the irregularities in the selection process inasmuch as they submit that the candidates who have been selected were already predetermined. Yeah.
प्रेसिडेंट का डॉटर और मेंबर का डॉटर इन लॉ का अपॉइंटमेंट
The appointment of daughter of the president of the school and daughter-in-law of
member of the
managing committee have been appointed. However, it is not clear as to whether they formed a part of the selection committee. It further appears from the writ records that the petition number 1 and 2 had also represented before the Director Secondary Education alleging irregularity in the matter of appointment, while letter dated 10/3/2023 and 20/3/2023 and immediately thereafter the writ petition has been filed on 27/4/2023. Considering the fact that the approval regarding appointment is to be granted by the respondent number 2, this court is of the view that the entire matter is required to be looked into by respondent number 2 and the writ petition at this stage cannot be entertained. And this court is not inclined to entertain this writ petition at this stage. However, the petitioners having raised their grievance before respondent number 2 shall however, it will be open to the petitioner to approach the respondent number 2 so that their concern is also taken care of while grant of approval. Accordingly, this writ petition is disposed of, enabling the petitioner to approach the respondent number 2 by filing a fresh representation along with the writ records. The respondent number 2 shall scrutinize the relevant records while considering the matter of approval regarding appointment in the minority institution, respondent minority institution. It is, however, it is made and also pass a reasoned order in connection with the matter of approval. It is also observed that in case the approval has already been granted, no fresh order of approval be passed and a copy of the same be forwarded to the petitioner through speed post. The reasoned order be as aforesaid be passed within अभी तो रीजन ऑर्डर के लिए क्या टाइम फ्रेम है
4 सप्ताह
2 months ठीक है the respondent number 2 while passing the reasoned order will also grant an opportunity of hearing to the respondent institution and in case the and also the concerned candidates.
Petitioner also.
Yes, petitioner also. The state petition is accordingly disposed.
Item 21, WPS 2778 of 2023.
Respondent number 4 and 5 has filed counter affidavit. Other respondents should also file the counter affidavit.
State is the main condition.
WPS number 2778 of 2023. Counsel for the a counter affidavit has been filed on behalf of respondent number 4 and 5. Counsel for the respondent number 1 to 3 is also directed to seek instruction and file counter affidavit in this case. Counter affidavit by 24th, rejoinder by 10th, post on 14th under the heading
Should there is a similar matter, Your Lordship, serial number at serial number 29, Your Lordship.
There also respondent number 4 and 5 has filed counter.
No, Your Lordship, in that case, pleadings is complete. There is another matter which is tagged to that matter. In that matter, pleadings is not complete, Your Lordship. No counter affidavit has been.
Let the case be called out. You just wait for something.
It may be tagged to
Item 22, WPS 2780 of 2023.
Yes.
This is the bid for appointment on the basis of compulsory appointment as per the scheme. Not previously what has happened, the petitioner mother on which as per the was forcefully superannuated. Thereafter he had filed the writ application.
What is the date of superannuation of mother?
The date of superannuation 31/5/2004.
31/5/2000. Then
that forceful retirement was challenged before the writ court, Annexure 3, page 30. That was allowed.
when was the writ petition filed?
The writ application was filed.
Give me the writ number.
Order is annexed.
Writ number.
WPS number 4643 of 2009.
After how many years? 5 years.
But that was forceful retirement.
That's right.
Thereafter
She
the
was made
mental-
to retire on 31/5/2004. Anyways, it was entertained. There is no problem.
Entertained and allowed also.
Okay. What was the
Thereafter
scheduled date of retirement according to you?
Scheduled date of retirement was date of birth is 1/6/1954. He has to superannuate. As per the actual date of retirement, 2018.
बताइए डेट बताइए.
But she has to retire in the year 2018 as per the date of 8.
So her scheduled date of retirement was 2008. Then what happened?
Then Lord, the respondent Lord in an imaginary date they have superannuated her. Then that order of that was challenged. Then medical board was constituted. Then she was allowed Lord, and an agreement was entered. That was said that yes, this agreement is by this agreement we will allow and we will not give any other benefit like compulsory appointment and retirement.
Where is that agreement? That is under ID Act.
That was not under ID Act, therefore it was held, it is not an ID Act, lecture 4, page 34, it was declared in the LPA.
That agreement has been set aside.
Yes.
Where is that agreement?
That agreement, I have not annexed, order is there, lecture 3, page 30. Paragraph page 32 is the relevant portions of the order. Moreover, it was well settled that when there are two interpretations, it must go in favor of the have-nots. Moreover, the settlement is not entered into a conciliation proceeding.
That's right, you forget about that. So there was an agreement and you were made to join, and ultimately what happened in the LPA?
Ultimately, I was made to join, and LPA, my lord, the further, since that settlement was said, it is not in accordance with the law and is contrary to the Industrial Dispute Act, then they will responded challenge that order. Annexure 4, page 34, my lord.
Yes, I have seen that.
Yes.
Page number 54, you come, page number 54. You were also found entitled to back wages.
Yes.
Right?
Yes.
25/12/03. Back wages given to you?
Yes, yes, back wages have been given.
What is your grievance now?
Now, my lord, as per the, my lord, this scheme, I am entitled, my son is entitled for the compulsory amount, they are not giving that.
Compassionate appointment?
Yes, my lord.
After retirement?
Lord, it is a, my lord, I can explain, it is a voluntary retirement scheme. And as per the voluntary retirement
Just a
scheme,
moment.
Lordship.
You were given, your scheduled date of retirement was 31/12/2008.
Lordship.
You have given the back wages till 31/12/2008, taking your date of retirement as 31/12/2008.
Lordship.
Where is the question of compassionate appointment?
Lord, since this application was filed for the, my lord, VRS as per the scheme, and if that was accepted, then, my lord, I am entitled for the compulsory retirement. That was the whole
So
case.
this date 31/12/2008 was the cutoff date of your VRS date.
VRS date, my lord.
From where do I get that?
Because what has happened, my lord, I just appreciate.
हम appreciate कर रहे हैं. आप हमको exact date of date
जी वो
आप
डेट हम
retirement
तैयार नहीं किए, नहीं तो हम
तैयार नहीं किए, ये तो fundamental चीज है. Yes, what was her date of retirement?
To take instructions, but
चौवन
54.
The date of birth was 1/6/1954
आप कल चले आइए.
and was wrongly
Counsel
entered.
for the parties are present. Close this case tomorrow. कल सारा डेट लेके आइए.
जी.
स्कीम लगाए हुए हैं जिसमें आप क्लेम कर रहे हैं.
नहीं लगा हुआ नहीं, लगा देते हैं तो NCWA का स्कीम है वो.
भैया आप महान हैं, हम महान नहीं हैं. बिना देखे हमको समझ में नहीं
लगा
आता.
देते हैं कल उसमें.
आप लेकर आइए, कम से कम स्कीम लेके आइए, भले मत लगाइए.
Item 23 WPS 2783 of 2023.
Petitioner.
It's not petitioner, alleged that he was also shortlisted, and another person who was shortlisted, he was selected on the basis of experience certificate, and he has the person who was selected, he had produced the certificate that he was working in an organization which is said to be working illegally in two post laws. Page 56. Page 59 is the
You are
certificate.
only concerned with appointment of respondent number 5.
My lord, if he will be removed, my lord, I will be selected. Kindly see, my lord, the certificate, the experience certificate which he has produced. Page 69.
Yes.
My lord, here kindly see the date of work. 16/1/2007, 31/3/2008. Here, my lord, to the another organization, the same date, page 70, 15/4/2002, 30/7/2016. So if he is selected, not kindly see the list. Sunil Kumar Tiwari, 515, my name 516. He has been selected, Lord Archer, page 56. He was selected on the basis of 4 certificate. He cannot work, Lord, simultaneously in a same post in a 2 more organization.
No, it's not like this. You read page number 70.
Lord, sir.
You read page number 70. That is an additional work of 2007-8.
Lord,
Fourth last line.
प्रमाणित किया जाता है कि सुनील कुमार तिवारी, ब्रजेश्वर तिवारी, जिला गढ़वा के निवासी है, उक्त छात्र कार्यक्रम अंतर्गत प्रबंध समन्वयक सह सचिव मझगांव के पद पर दिनांक 16/1/2007 से दिनांक 31/3/2008 तक सफल पूर्वक कार्य किया. If Lord, he was working here, he cannot work, Lord, at page number 70. Even in additional, because he is in regular.
Whether he can work or not work. But this only certifies that he has done some additional work.
Lord,
You
not-
said see page number 70.
Lord, I
वोकेशनल
am on
कवरेज
page
के
number 69,
अतिरिक्त वर्ष 2007-8 में इसमें अंकेक्षण का कार्य किया है.
Lord, I
अंकेक्षण
just-
का कार्य तो कर ही सकते हैं ना
Lord.
मल्टीपल एजेंसीज. Where is the legal bar?
Lord, I am also coming on page number 70. Lord, प्रमाणित किया जाता है कि पिता स्वयं परियोजना पदाधिकारी के पद पर, not on अंकेक्षण, he is working on परियोजना पदाधिकारी, प्रोजेक्ट ऑफिसर के पद पर 15/4/2002 से 30/7/2007 केंद्र प्रायोजित योजना के तहत स्वर्ण जयंती ग्राम रोजगार योजना अंतर्गत स्वयं प्रशिक्षण, ट्रेनिंग एवं आधारभूत संरचना निर्माण, सामुदायिक संगठन, क्षमता संवर्धन कार्य, साक्षरता कार्यक्रम, सूचना अधिकार अधिनियम के प्रशिक्षण तथा जागरूकता कार्यक्रम में अतिरिक्त वर्ष, एडिशनल ईयर, वर्ष 2007 एवं 2008 में मनरेगा सामाजिक
अतिरिक्त
अंकेक्षण
वर्ष
कार्य किया.
नहीं के अतिरिक्त इन्होंने इसका ऑडिट का भी काम.
Lord, he worked for the period 15/4/2002 to 30/7/2016 for these work, and again in addition to these work he has worked for this also.
He has
so this
worked
is this.
for audit of this organization.
Lord, not. I
Show me
again,
that there is some.
Lord, I will read this only. Lord. I will read this only. This, Lord, I again read, Lord. 15/4/2002 से 30/7/2016 तक केंद्र प्रायोजित योजना तथा स्वयं इन ईड्स के अतिरिक्त वर्ष 2007-8 में मनरेगा सामाजिक अंकेक्षण कार्य किया. दैट इज एडिशनल, बट एक्चुअल वर्क इज परियोजना पदाधिकारी, a project officer. So original post held by that in this rural improvement charity as project officer. And again Anubhav Praman Patra page 69.
Yes, that we have seen.
Lord,
It is the same period.
So
It
same
is the
period.
same period.
He cannot-
16/1/2007 to 31/3/2008.
Lord, he cannot work.
No, you just show me something. It is not a matter of working in two places.
How can one person can work in two posts? And in
Yeah,
two
how can,
places?
I'll tell you how can. So far as audit is concerned, people are deputed to go and they are permitted to go to conduct audit in different organizations, right? So there is no legal bar.
Lord, had it been an audit?
It is audit.
No,
Audit ka
Lord,
kaam ka.
it is not an audit. Kindly see, Lord, it is not an audit. He was working as Pariyojana Padadhikari, not an audit officer. or not he has, Lord,
But these
is fully
certificates
working
are
on
not
it.
forged certificates.
My lord, it is because one person cannot work in one organization as project officer under the Manrega and simultaneously before the another organization as a, my lord, project officer in another organization under the Manrega. And if it has been done, then my lord, if it is to be valid, to be said that those both the certificates are valid, then my lord, inquiry is to be initiated. How it could? It could not be. Because this,
Which paragraph are you referring to of your writ petition?
Lord, page 69,
The paragraph of the writ petition.
Lord. Lord, paragraph 19.
ये पैरा 18 का क्या मतलब है? As per RTI, respondent number 5 not shortlisted.
Due to not enough experience, Lord, I have shown that my serial number, Lord, just see the select list.
ये not
Page
shortlisted
56.
या
Not shortlisted, Lord. Because what has happened, he was also not shortlisted. He was not even called for the interview. Lord, kindly see page 56. Lord, you will therefore make me understand. Page 56, the select list. Page 51, serial number 515, Sunil Kumar Tiwari. He was also not shortlisted. Even thereafter he was appointed. I was also not shortlisted because of not enough experience. He had produced the certificate that he was working in two organizations on the same day. And paragraph 19.
Respondent number 5 is Sunil Kumar Tiwari.
Lord. Kindly see paragraph 19, I have made the specific statement.
And ultimately he was selected.
Ultimately he was selected. He has not even faced the interview.
Where is the learned counsel for the petitioner and state are present. The learned counsel for the petitioner has submitted that the respondent number 5 was not shortlisted due to inverted comma not enough experience, as is apparent from page number 56 of the writ petition. But in spite of that, he has been selected, as is apparent from Annexure 3. He submits that consequently the respondent number 5 did not face the interview at all. He has further submitted that he has overlapping period of experience as contained in page number 69 to page number 70. Page number 69 indicates that he had worked from in the district, in the office of district literacy, क्या बोले साक्षरता का समय?
Paragraph 19, it has been verified. District Literacy Committee.
District Literacy Committee during the period from 16/1/2007 to 31/3/2008, and also in rural improvement charity within bracket RICHA bracket close during the period from 15/4/2002 to 30/7/2016. The learned counsel submits that it is not possible for one person to work at two different places at a time. However, from the perusal of page 70 of the writ petition, this court finds that the petitioner has been given experience certificate during the for having working with rural improvement charity within bracket RICHA for the period from 15/4/2002 to 30/7/2016. And in addition, it has been mentioned in the same experience certificate that he has worked in the year 2007 and 8 in Manrega for social audit. The counsel for the petitioner has not been able to show any such provision. No, excellent. The learned counsel for the respondent state is directed to seek instruction and file a counter affidavit in the present case with regard to the aforesaid submission made by the petitioner. The affidavit be filed by the respondent number 3 after obtaining due information from respondent number 4. So, the counter affidavit be filed by 24th, rejoinder by 10, post on 14th under the heading for redaction. Notice अभी नहीं करेंगे. At this stage, this court is not inclined to issue notice upon the private respondent number 5.
With the advertisement itself,
We'll
there
see
was
that.
the criteria to file the experience certificate.
We'll see that. Let them clarify the position and then only we'll issue.
Yes, yes.
Passover case item change, WPS 1405 of 2023.
Yes, petitioner. Dates बताइए.
Number 16 now, annexure 3. Page number 20.
हाँ बताइए. पढ़िए.
आपने स्वर्गीय पति चंदू भूया के उपरांत श्री अशोक भूया की नौकरी के लिए आवेदन दिया था. यदि जांचों उपरांत अशोक भूया पुत्र की जगह दामाद साबित हुए थे, अतः नियोजन का दावा रद्द कर दिया गया था. पुनः आपने पुत्री मंगली कुमारी के नियोजन हेतु आवेदन प्रस्तुत किया है. अशोक भूया के लिए नौकरी प्राप्त करने का प्रयास छल और धोखे से भरा हुआ है. ये आपने जो आवेदन
डेट ऑफ डेथ बताइए.
डेट ऑफ डेथ हम थोड़ा सा इसको
2012 हम बता रहे हैं ना. आप फाइल तो पढ़ते नहीं, घर पे टाइम नहीं मिलता.
12 का है, हमने समय पर आवेदन दिया.
तो आप
तो
इसीलिए डेट ऑफ बर्थ ये मत बताइए, हम देखेंगे समझेंगे. डेट ऑफ डेथ बताइए.
अशोक भूया जिसके बारे में कहा जा रहा है, अशोक भूया
आप कॉम्पैशनेट अपॉइंटमेंट में टाइमलाइन नहीं बताइएगा तो कैसे कॉम्पैशनेट अपॉइंटमेंट का केस डिसाइड होगा. पहला सवाल कॉम्पैशनेट अपॉइंटमेंट में आपके बहुत सारे मैटर्स रहते हैं.
NCW, this is guided by NCW.
यस, इसीलिए डेट ऑफ डेथ बताइए.
डेट ऑफ डेथ इज 2012.
हाँ, डेट बताइए ना. 23/8/2000. ठीक है. उसके बाद
thereafter see the compensation application for compensation department was filed by the trade union.
By
he
the
only mentioned
by the
trade union. He contacted madam. See the
union had filed it.
Through the union she filed
okay.
application.
The wife filed that.
Wife. And madam,
just a moment. Please hold on. Hold on. Application through union.
Union. For the appointment of Ashok Bhuya.
Of son-in-law.
That is not son-in-law. And it's a two mechanic mistake. It is
for
son
appointment of son-in-law.
Not son-in-law.
For appointment of son.
Son. And that son was died in
second, please. When was the application filed?
Son was died.
When was the application filed?
That application was filed. I cannot say the date, but Ashok Bhuya had already died.
When?
On 13/5/2000, prior to 12 years. of the death of the deceased employee.
तो फिर एप्लीकेशन वाइफ ने अशोक भुइया के नाम पे कैसे किया?
वो तो ट्रेड यूनियन की गलती से वो फाइल हो गया था।
ट्रेड
हम
यूनियन
यहाँ
की
पर-
गलती से
यहाँ
बिना
पर-
इंफॉर्मेशन दिए फाइल हो गया था।
ये हम इनके फादर का नाम भी दिए हुए हैं। एनेक्सर 2 में देखा जाए अशोक भुइया के फादर का नाम भी चंदू भुइया है। Who was the deceased employer? It was not the.
तो that particular application through trade union is null and void, है ना? भाई आप तो एज ए मदर
बता देना मुझे जो
नहीं हम आपसे पूछ रहे हैं एज ए मदर यू कुड नॉट हैव गिवन द नेम ऑफ योर डिसीज्ड सन फॉर एम्प्लॉयमेंट.
When she came to know, she applied for her daughter.
When did she come to know and when did the daughter apply?
She came to know that this is my lord, that has wrong has been mentioned. Then she.
When did she apply afresh? बेटी ने कब अप्लाई कर दिया? डेट बताइए.
रिक्वायर्ड डॉक्यूमेंट 21/9/19 को दिए.
जिस दिन डेथ हुआ था बेटी का क्या एज था?
At that time she was, my lord, I feel she had been minor. Because there is a provision to keep in lab.
वही ना, वही एज बताइए. आपको तो पता है ये सब बेसिक सवाल है. बताइए एज बताइए बेटी. लाइफ स्टोर रोस्टर के लिए भी तो 15 साल होने की जरूरत है, राइट? और उसके लिए भी एप्लीकेशन फाइल करने की जरूरत है. उसके लिए भी एप्लीकेशन फाइल करने की जरूरत है. ऑटोमेटिक नहीं होता.
In the case of Mohammed, it is decided this is a duty of the respondent, my lord.
अच्छा, एनीवेज आप हमको डेट उसका उम्र बताइए. And where is the application for compassionate appointment? Where is your application for compassionate appointment? That's all?
That was my lord. She was referred to medical board. She was examined by the medical board also. And her age,
लिखिए. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petition has submitted that the ये सजनी का मीन कौन है?
Chandika is the wife of the deceased employee. Chandu.
Okay. The learned counsel for the petition has submitted that the husband of the petitioner was an employee of the respondent who died while in service on 23/8/2012. The learned counsel further submits that since the petitioner at the time of death, the son of the petitioner, namely Ashok Kumar Bhuiya, had expired as back as on 13/5/2000, and the deceased left behind only his wife and one daughter, namely Mangli Kumari. The petitioner, being illiterate and had no knowledge with regard to taking up any step for employment of her daughter, consulted a trade union who took LTI imprint of the petitioner on various documents, but no employment was provided. The Learned Counsel submits that there was no question of making any application for compassionate appointment for Ashok Bhuiya, as he had died as back as on 13/5/2000. She submits that with the help of it has been submitted that with the help of some of the officers, the petitioner applied for compassionate appointment of her daughter, namely Mangli Kumari, along with required documents on 21/9/2019. And her daughter was also asked to appear for assessment of age by medical board, but by the impugned letter dated 29/2019, the claim of compassionate appointment has been rejected by mentioning that upon due inquiry, it was found that Ashok Bhuiya was not the son but the son-in-law of the deceased employee. The Learned Counsel submits that that Ashok Bhuiya was the son and not the son-in-law, and the application filed on behalf of the union has no relevance in as much as they had taken her LTI and had suo moto taken up the matter. यही है कहानी. After hearing the Learned Counsel for the petitioner, this court finds that admittedly the husband of the petitioner had expired on 23/8/2012, and even if the argument of the petitioner is taken into consideration that no application was pursued by her through the union, then also the first application which was filed by the petitioner for compassionate appointment was only on 21/9/2019. That is after expiry of more than 7 years from the date of death of her husband. In view of the aforesaid facts and circumstances, and further, this particular writ petition has been filed on 4/3/2023 after expiry of about 4 years from the date of the impugned order. Considering the facts and circumstances of this case and the fact that the husband of the petitioner had expired way back in the year 2012, the very purpose of grant of compassionate appointment stands frustrated. Accordingly, there is no merit in this petition, which is hereby dismissed.
Item 24, WPS 2797 of 2023.
Petitioners for their absorption and continuity of their service on the post of Gage Khalasi as a seasonal worker. Questions follow. In spite of their services being rendered from prior to
Seasonal worker का कोई absorption होता है?
Seasonal worker they have been appointed earlier in the Bihar, and after creation of the Jharkhand, some part of the levels, seasonal workers were.
Where is your appointment letter?
That is one annexure 1. It starts from page 19. The Gage Khalasi list is that page number starts from page number 23, and the name of the petitioners stands at serial number 24, 25, 28, 31, 34 onwards. That is till page 26. Actually, what happened in this case, they have taken the work from these petitioners, right? From
आपका तो paragraph 7 में आपका ये para 15 of the counter affidavit में there is a clear cut averment that you have not been working on the post continuously each and every year.
Annexure 2 is there in my support for that. That is the bank pay slip. That it is up to 220.
Up to से नहीं ना होगा, continuously working होना चाहिए.
Seasonal work का तो duration होता है 6 month का.
नहीं, हर साल का भी तो होना चाहिए ना. हर साल आपको पेमेंट मिला है?
हाँ, हर साल मिला.
कहाँ है?
They have I could not annex, but I.
You annex it. Rather, in response to the counter affidavit, you annex. In paragraphs 15,
Yes,
they
yes,
have made
yes.
specific statement.
And even when in the Bihar Malot, they have been Malot, they have been regularized, their services have been regularized.
बिहार से हम लोग नहीं चलेंगे.
नहीं तो जजमेंट है
अब
सुप्रीम
बिहार के मतलब उसको
in light of the judgment of Supreme Court below that was done. क्योंकि
in
हम
light
तो
of judgment of Supreme Court, तो वो
Yes.
भी लगा दीजिएगा. ठीक है?
Your Lordship, may kindly peruse annexure A of the counter affidavit, point number 7, Your Lordship. Therein it has been specifically mentioned that no person will be rendering service for 2 consecutive or continuous financial years, Your Lordship. So this is the point that we are putting forth.
Let him respond to the counter. This counter affidavit has been filed by whom?
Your Lordship, the counter affidavit has been filed by the Executive Engineer, Master Planning Division, Ranchi.
It has been filed on behalf of all the respondents.
Yes, Your Lordship. Your Lordship.
224.
Okay. Counsel for the parties are present. The learned counsel for the petitioner has submitted that. Petitioners has submitted that the petitioners have been working every year right from 2010. However, no supporting document to that effect has been filed by the petitioners. The learned counsel appearing on behalf of the respondents has submitted that as per the terms of employment, the persons like the petitioner were not supposed to work for consecutive, for
2 years.
for 2 consecutive years. And therefore, there is no question of petitioner being continuously working since 2010. She has relied upon the counter affidavit. At this, counsel for the petitioner prays for time to file a rejoinder to the counter affidavit and also bring on record supporting documents that the petitioners have been working on during each and every year in continuity. Rejoinder be filed by 4, post this case for final disposal on 8th. जो जजमेंट आपको करना है, रिलाई करना है, उसको लगा दें.
Item 25, WPS 2825 of 2023.
Petitioner.
Matter relates to family pension. This is a family pension entitled from initially the petitioner has approached before petitioner report and the report was passed and direction. Then it's a 5 of the petition, 20 plus 31.
This is railways.
Yes, madam.
Railways will have a
Yeah.
jurisdiction in CAT,
Yes.
not before this court.
As directed by the board.
No.
Reason order has also been passed.
Reason order might have been passed. We will not entertain this writ petition. आप पता कर लीजिए. हम लोग रेलवेज के अगेंस्ट में पिटिशन हमको नहीं एंटरटेन.
कैट में ही जाएगा वो.
कैट में जाएगा ना. कहाँ काम करते थे ये?
AC Railway themselves Tata Nagar.
This court will not have jurisdiction. आपको ऐसा इंस्ट्रक्शन है कि हम बोल दिए इसलिए बोल दिए?
नहीं हम तो बोलते ही, लेकिन अब उनका बात करने देने देखिए तो नॉर्मल है कि
Learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the respondents have submitted that the present petition is not maintainable as the petitioner was working as assistant personal officer within bracket W bracket close Southeastern Railway Tata Nagar, and the petitioner has an appropriate remedy before Central Administrative Tribunal. At this, the counsel for the petitioner has submitted that the impugned order has been passed pursuant to order passed by this court in WPS number 4379 of 2018. However, from the perusal of the order passed in the writ petition, it appears that no objection was taken with regard to the jurisdiction of Central Administrative Tribunal आप कल पता करके क्लाइंट से बात करके बता दीजिए. Let this matter be posted tomorrow so that the petitioner may seek instructions. Withdraw करके टाइम फ्रेम हो जाएगा तो आपको दिक्कत नहीं होगा, नहीं तो दिक्कत है. 2001 में आपके हस्बैंड का डेथ हुआ.
Item 26 WPS 2879 of 2023.
Yes, petitioner.
Matter relates to compassionate appointment of married daughter, my lord.
Date of death.
Date of death, my lord. 2004.
8/5/2009.
8/5/2009.
उसके बाद आपका कितना उम्र था उस वक्त?
The petitioner's date of birth in my lord.
The petitioner नहीं, बेटी का.
बेटी का बोलना है.
हाँ.
15 March 1986 में.
15/3/1986. And date of marriage?
Date of marriage in my lord. 2008 my lord.
2008. Marriage. Okay. 2009 से लेकर अभी तक क्या कर रहे थे?
2009 के बाद my lord, in 2014 I applied for the same.
Date.
But the
Date.
state.
Date बताइए date.
Application date my lord. That is not my lord. I have not taken that my lord. They found the application in order and ultimately meeting was held on 14/11/14 my lord. And in that meeting my lord, others applications were allowed and my applications was rejected only on the ground you are married one and that is not permissible.
Let us see the impugned order.
My lord, page 19. Last paragraph.
Kindly read it.
कुमारी शोभा बर्णवाल, पिता किशोर प्रसाद, भूतपूर्व BHW व्यवस्था केंद्र महेशपुर को अनुकंपा के आधार पर नियुक्ति संबंधी आवेदन पत्र की जांच समिति के सदस्यों द्वारा की गई. संलग्न पत्र के साथ सभी वांछित कागजात संलग्न हैं तथा उनकी शैक्षणिक योग्यता ISC उत्तीर्ण है. आवेदिका लिपिक के पद पर नियुक्ति हेतु आवेदन दिए हैं. सरकार के संयुक्त सचिव कार्मिक और प्रशासनिक सुधार विभाग बिहार पटना के पत्रांक 13293 दिनांक 5/10/91 में वर्णित प्रावधान के अनुसार आश्रित के श्रेणी में मृतक सेवक की पत्नी.
What do you say?
My lord.
My lords, in the year 2009, my lords.
This was rejected in 2014.
14, my lords.
14 से लेके अब तक
Yes.
क्या कर रहे हैं?
So after 14 my lord, they assured we are making our own policy on a for compassionate appointment. You please wait.
And C,
कहाँ पर लिखे हैं एश्योरेंस आपको दिए राइटिंग में कि वेट
नहीं
करते
my lord,
रहिए
writing में तो कोई देता नहीं है. हम
कहाँ लिखे हैं कहाँ लिखे हैं where have you mentioned
He has not mentioned anywhere.
where have you mentioned
my lord ये हम मेंशन नहीं किया. 14 के बाद my lord हम देते रहे. लास्ट में फिर हमको 2015 में इनकी पॉलिसी भी आ गई. 15 my lord इनकी पॉलिसी भी आ गई और पॉलिसी में उसका प्रोविजन भी आया.
My lord, in our
you पेज नंबर 13 में आइए पेज नंबर 13 you have annual income also
my lord, annual income certificate is given. परिवार प्रमाण
क्या काम करते हैं आप
my lord, परिवार का एनुअल इनकम लिखा हुआ है my lord 60,000. Whatever they wanted, everything was submitted my lord. पारिवारिक सदस्यता का प्रमाण पत्र भी सबमिट किया, वो भी किया गया. इसके बाद फिर जो 19 में पॉलिसी भी आ गई जिसके अंदर उसका प्रोविजन हुआ. प्रोविजन में मैरिड डॉटर के लिए प्रोविजन भी हुआ. लेकिन देयर आफ्टर ऑल्सो दे टोल्ड कि हम लोग कर रहे हैं लेकिन वो रिप्रेजेंट करते रही. लास्ट में माय लॉर्ड 2021 में इन लोगों ने एक रिप्रेजेंटेशन का जवाब दिया और सिर्फ उसी अर्लियर जो रिजोल्यूशन था कमेटी का रिजेक्शन ऑर्डर उसी को कन्वे कर दिया.
where is that conveys where is that annexure 2
Annexure 2, page 20, my lords.
21
My lords, already in the year 2014, my lords, the claim of the petitioner was rejected, my lords. That now, my lords, firstly, my lords, in the year 2009, the
देखिए WPS number 2879 of 2023. For the learned counsel for the parties, district petition has been filed for the following relief. The learned counsel for the petition has submitted that the date of death of the deceased employee is 8/5/2009 and an application for compassionate appointment for the daughter was filed on in the year 2014
married daughter.
and the same was rejected by order dated 14/11/2014 as contained in Annexure 1 to the writ petition by mentioning that in terms of the circular of Bihar dated 13293 bearing number 13293 dated 15/10/1991 the married daughter was not included. The learned counsel submits that the daughter of the daughter of the deceased employee who is the petitioner before this court got married in the year 2008. The learned counsel has also submitted that thereafter the petitioner has been pursuing her case and another order was ultimately communicated to the petitioner as contained in Annexure 2 dated 11/10/2021 referring to the earlier order of rejection of the year 2014. The learned counsel submits that the action of the respondents in making a distinction between a married and unmarried daughter is not permissible in the eyes of law, and therefore action of the respondents is violative of Article 14 and 15 of the Constitution of India. Therefore, the impugned order are fit to be set aside. The learned counsel, appealing on behalf of the respondents, has opposed the prayer and has submitted that the death had occurred way back in the year 2009. The application was rejected in the year 2014. The subsequent communication dated 11/10/2021 does not revive the cause of action as it only referred to the rejection order way back in the year 2014. He submits that the very purpose of compassionate appointment has frustrated, and therefore no relief be granted under Article
One more
226 of the
submission, my lords.
Constitution.
The brother of the petitioner is also my lords in service. That's what we have stated in the account.
He submits that a counter affidavit has been filed indicating that the brother of the petitioner is
employed, my lord.
Is duly employed.
Yes,
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the ex-employee had expired on 8/5/2019 and the application for compassionate appointment was rejected on 14/11/2014. But no challenge was placed to the same. The same was rejected on the basis of circular issued by the state of Bihar way back in the year 1991. This court further finds that that another communication was made to the petitioner dated 11/10/2021, referring to the earlier order of rejection dated 14/11/2024. This court is of the considered view that the fresh order dated 11/10/2021 does not revive the cause of action inasmuch as the same was reiteration of was only referring to the earlier order of rejection dated 14/11/2014. And now the present writ petition has been filed challenging the earlier order dated 16/10/2014 as well as the communication dated 11/10/2021. The fact remains that the brother of the petitioner is already employed, as has been stated in paragraph, which para?
12, my lords.
Para
12, my lords.
12 of the
Pratap Kumar Barnwal, my lords.
para 12 of the writ petition of the counter affidavit.
Of the counter affidavit.
No rejoinder has been filed.
My lord, counter affidavit we have not received.
No rejoinder has been filed to the
Counter affidavit
Counter
itself
affidavit.
is not received, my lord.
Okay, forget about it. At this stage, the counsel for the petitioner has submitted that he has not received a copy of the counter affidavit. However, considering the fact that the father of the petitioner had expired way back in the year 2009, the order of rejection was passed in the year 2014, which was also reiterated by memo dated 11/10/2021. The very purpose of grant of compassionate appointment to the petitioner has been frustrated, and this court is not inclined to grant the relief as prayed for by the petitioner in this case, which is accordingly dismissed.
Great.
With the permission of the court, my lord, we'd like to withdraw case as serial number 49.
49.
So supplementary list 49.
The learned counsel for the petitioner. Are you for the petitioner?
Yes, ma'am.
Are you the advocate on record?
Yes, ma'am. Abhishek Gupta is ma'am.
The learned counsel for the petitioner seeks permission to withdraw this petition. Permission is granted. Accordingly, this revision application is Criminal Revision 223 of 2019 is dismissed as withdrawn.
Sign कर लीजिए. हाँ, जा सकते हैं. सप्लीमेंट्री कंटिन्यू करेगा या खत्म होगा तब डेली में?
मेरा पहला है प्रोविजनल वेल 22